Welcome to our discussion of the judiciary, specifically the federal court system. So we'll look at a nuts and bolts overview first, and I think the first thing that we really need to clarify is that the Constitution is actually pretty vague about the judicial branch. Where the Constitution is very specific about what the president can and can't do and what Congress can and cannot do, the judicial branch has some specificity in terms of how justices are appointed and the fact, as you see here in Article 3, that it says there's a Supreme Court and inferior courts, but really the rest is left up to Congress. And Congress started doing that in 1789 with the Judiciary Act of 1789. Which has been updated several times since. So here are some things to remember from that act and from the updates. The federal courts have limited jurisdiction. They can only hear certain kinds of cases, and we will talk about what those are. There's a three-tier system in terms of how you move through the general trial courts and appeals. That goes from the district court, which is the most common trial court, to the circuit courts, which are the most common intermediate appeals courts, and usually the final stop for appeals, and the Supreme Court, which is the final appeals court. It does have some weird original jurisdiction, cases that are heard there and only there, but we'll talk about that. And then broadly, as I mentioned, Congress defines what the Supreme Court can hear as an appeals court. So appellate jurisdiction means the ability to hear appeals from the circuit courts below. And this is typically what we think about when we think about Supreme Court cases. But there are also cases, usually only a couple a year at most, that are original jurisdiction cases. And these are cases that start and end in the Supreme Court. And they are usually having to do with one state suing another state. And for the duration of this lecture, understand that SCOTUS means Supreme Court of the United States. And so we will be referring to the court or SCOTUS interchangeably, but just when you see SCOTUS, know that that means Supreme Court. So what gets heard in federal court? This is a very broad overview of the federal court system. So as I had mentioned, these are the district courts that I had mentioned that are typically where you would start. You would go up, if you had an appeal, to the appeals courts. There are 94 district courts, and there are 12 appeals courts. These are geographic. The district courts, there is at least one in each state. Some states have two, and some districts have divisions. So in Michigan, we have an Eastern District and a Western District, and the Eastern District has a Northern Division and a Southern Division. The appeals courts, there's 12 of them throughout the country, and then up to the Supreme Court. There are other specialty courts like tax court, claims court, international trade court, and then the armed services. They have their own procedures. We will be focusing on this track right here, which is the bulk of the cases. So federal courts generally deal with two types of cases, civil and criminal. Civil cases are lawsuits between individuals or organizations that are based on contracts or civil laws or constitutions. This is quite literally when someone says, I'm going to sue you, probably what they mean, a civil lawsuit. A criminal case is when the government charges someone with a crime, and that can be federal or state in nature. The other cases, which usually fall into one of these other courts, are things like bankruptcy cases, trade infringement cases, patent and trademark infringement, military tribunals. These usually have their own specialty courts or subcourts. So you can see Michigan is divided into two districts. This is the Eastern District, and then you can see the court locations in the Eastern District and the Western District. And then this is the circuit court map. Notice Michigan is in the 6th Judicial District, circuit, or it's not district, circuit, along with Ohio, Kentucky, and Tennessee. So determining whether something is a federal case or a state case can become kind of tricky. In fact, there are lawyers that don't always know the difference. So generally speaking, for our purposes, there are two types of cases that we'll be dealing with federal cases. There are civil cases and criminal cases. In civil cases, there are two ways you can have a federal case. Otherwise, it's a state case. The first is subject matter jurisdiction. And what that means is there is a federal law that is implicated in your lawsuit. So if you are suing an employer for violating the federal Civil Rights Act, let's say they terminated you and you believe it's on the basis of race, this is subject matter jurisdiction. Diversity jurisdiction is a civil claim between two parties who are residents of different states and involves a matter of $75,000 or more. So in order to not give one party in the case preferential treatment, let's say someone lives in Ohio, another person lives in Michigan, you wouldn't want the Ohio person to get preferential treatment in Ohio, and likewise the same for the Michigan person in Michigan, so they can go to federal court as long as it involves something over $75,000. Then there are criminal cases. Federal criminal cases are actually quite limited. These are trials for violations of federal crimes, so things like wire fraud, money laundering, terrorism, etc. And then the appeals for federal crimes go through the federal system as well. One way in which state court criminal cases can get into federal court is after a conviction, there's a procedure called habeas corpus. And habeas corpus appeals are generally appeals that say something like this. I know I was convicted below, but the court below, let's say in Michigan, violated my constitutional rights by not eliminating evidence that was found under an unlawful search and seizure. So that's a habeas corpus appeal. It's a criminal appeal that challenges the constitutionality of a crime in federal or state court. State cases are pretty much everything else. So civil cases are any tort, so any wrongful action like a slip and fall or an intentional infliction of emotional distress. Those are state cases. Contract cases, if you have a contract with someone, generally that goes to state court. And state statutory claims, so different states have different statutes you can sue under. And then all family matter claims, divorce, adoption, marriage, etc., name change, that all goes through the state court system. And then most crimes are also state crimes. Murder is typically a state crime. Theft is typically a state crime. Most of those things never get to federal court, and most things fall into the state court systems. So the kind of juiciest part of talking about the judicial branch is, of course, the Supreme Court. The Supreme Court is a long bench with 9 justices sitting behind it, hearing cases. And they generally hear 2 types of cases, original jurisdiction and appellate jurisdiction cases. There are 9 justices on the court. Congress could technically change this. They could change it to 13, they could change it to 7. But as of now, there are 9. 1 Chief Justice and 8 Associate Justices. And the jurisdiction needs to be talked about here. So the original jurisdiction, these are a few cases a year where the case goes directly to the Supreme Court, and only to the Supreme Court sometimes, but directly to the Supreme Court. So you have a right to take the case directly to the Supreme Court with these few cases. These are the only types of cases talked about in the Constitution. In Article 3, Section 2, it gives you 4 ways in which you can have original jurisdiction at SCOTUS. One is a dispute between the states, and not only does that have the right to go directly to the Supreme Court, that's the only place where those cases can go, is to the Supreme Court. So if Michigan sues Ohio, that case goes directly to the Supreme Court. Cases involving ambassadors or public ministers of foreign states. Controversies between the United States and a state. So if the federal government sued Michigan, that would go to the Supreme Court. And actions or proceedings by a state against the citizens of another state. That goes to the Supreme Court. So those are the original jurisdiction cases. Everything else will start down at that district court level. So this is the court's primary role. 99% of what they do is deciding whether to hear these cases and hearing these appellate jurisdiction cases. And the reason why I say deciding to hear them is because there's no automatic appeal to the Supreme Court. If you get a decision you don't like at that circuit court level, you have to apply for what is called a petition for a writ of certiorari, or a petition for writ of cert, or petition for cert, for short, but petition for writ of certiorari. And the court has to grant it and then docket your case for you to be heard at that court. And less than 1% of cases make it through this process. So it's unlikely that the Supreme Court is going to take your case. The case only gets taken when 4 justices on the court agree to hear the case. So 4 of the 9. It's called the Rule of 4. And the factors in determining whether to hear a case usually boil down to this. Is there an unresolved issue of legal interpretation? Not factual interpretation, but legal interpretation. And typically that involves one that has one circuit deciding it one way and another circuit deciding it another way. So what that's called a circuit split. Less than 1% of all petitions for cert are granted. So you can see how small of a portion of the cases this is, but yet that's most of what the Supreme Court does. So this is the path from the federal courts. Typically, the most common path is district court, circuit court, Supreme Court, if you get that writ granted. But there is a way in which you can appeal a state Supreme Court decision to the Supreme Court. And that is when a state Supreme Court interprets the federal Constitution. So let's say there's a case in Michigan and it involves some state issues and some federal issues, so it's in state court. It's a criminal case, most likely. That's usually when this comes up. It goes up to the Michigan Supreme Court, and there's a question about the Fourth Amendment right of against search and seizure. The decision could be appealed to the U.S. Supreme Court, and the court could hear the case just on that part involving the federal Constitution. They don't get to decide on the state court claims, just on the federal ones. But the most common is this district court, circuit court path. Then, let's say your petition is granted. You are one of the 1% of cases that gets heard by the Supreme Court. The first step is to submit written briefs. These are documents that detail the legal and factual arguments of the parties involved in the case. Then the court schedules your oral arguments, where you go and they ask questions and you give answers. Finally, the decision that the court renders is called an opinion. The majority opinion is the one that represents the official decision of the court. The one that gets the most votes behind it is the one that's the official ruling. There's also dissenting opinions that disagree with the ruling, and concurring opinions which agree with the end result but want to write for some other reason. So sometimes they think there's different reasons it should have been found that way, or they just want to add something. A couple of other players in the Supreme Court. Couple of other players include the petitioner and respondent. So people get confused by this. The petitioner does not necessarily mean the plaintiff below, but it's the party that wants the decision of the appellate court overturned. The respondent is the one who likes the decision below. Law clerks. Each justice has their own law clerks. And this is one of the most prestigious post-law school jobs you can get. Probably the most prestigious, unless somehow you get right out of law school and are appointed to the Supreme Court. But these are people who are usually attending Ivy League law schools or top-tier law schools, and are getting set up for a pretty prestigious legal career. And then finally, we'd be remiss if we didn't talk about the Solicitor General. I must clarify with you, write this down, the Solicitor General is not the Attorney General. These are two separate entities. The Solicitor General is the attorney that presents the position of the United States federal government to the Supreme Court. That is their primary job, is to go to the Supreme Court and say what the federal government thinks on an issue involving the federal government. And sometimes they're parties to the case, and sometimes the Supreme Court just says, well, we want to hear what the federal government has to say about this case. They are different from the Attorney General. The Attorney General is the top prosecutor of the country. The Solicitor General is kind of the top appellate attorney for the government. These are two different people. The Solicitor General argues before the Supreme Court. Now, we turn to an issue of judicial review and judicial interpretation in the case of Marbury versus Madison. The issue in this case is whether Marbury can take his post as a Justice of the Peace for Washington, D.C.
Jefferson was building a country, and he had a very extended vision of where things were going to go. And I think he became pretty hardcore about people who got in the way. And he saw Marshall as someone who was getting in the way.
The swearing in of Thomas Jefferson has got to be one of the great ironic moments in American history, because you have Chief Justice Marshall swearing in his second cousin, Thomas Jefferson, and both men pretty much by that time hated one another. They feel that the policies represented by the other person was detrimental to American civilization. It was as fundamental as that. So you have Marshall holding the Bible, Jefferson swearing to uphold the Constitution, which Marshall was absolutely sure he was going to destroy.
The first fight between Jefferson and Marshall was a fight picked by John Adams on his way out of town. That quarrel would spill into the United States Supreme Court. On paper, Marbury versus Madison involved a small technical question of administrative housekeeping. But in the political swirl of 1801, this seemingly straightforward legal case would determine the future of the court and test the cunning and ability of the new 45-year-old Chief Justice. Marbury versus Madison began with another breathtaking act of partisanship by the outgoing President John Adams. Just weeks before Jefferson's inauguration, the lame duck Federalist Congress had passed legislation swelling the federal courts, and Adams stuffed them full of anti-Jeffersonians.
At the very end, literally the last day of Adams' presidency, he was busy signing commissions for these federal judgeships, including these justices of the peace. And the hour got very late, and he had to get the commissions signed, and then they were sent over to the Secretary of State, who happened to be John Marshall. And Marshall had to put the seal of the United States on it, and then they were to be delivered to these designated justices of the peace.
John Marshall knows he can't deliver them all. He gives about half of them to his brother James to deliver. James doesn't get around to delivering them before time runs out. The key lesson of Marbury versus Madison is don't give important documents to your brother.
Of course, that's not the only important lesson of Marbury versus Madison. That is the factual background of Marbury versus Madison. The legal background becomes a little more complex. The question that ultimately had to be decided is whether the Supreme Court could invalidate a law of Congress. The reason being is that Marbury, instead of going to district court, filing a case and then going through the appeals, went directly to the Supreme Court. And he did so under this provision of the Judiciary Act called a writ of mandamus. And the writ of mandamus, you don't need to understand it, but it's essentially something that would allow someone to go directly to the Supreme Court to be heard. And the Supreme Court said in its decision that this part of the Judiciary Act of 1789 was unconstitutional, that the writ of mandamus was not part of the framers' intent in writing the Constitution. And so the court ruled actually on two things. The first was that it had the power to review acts of Congress, that essentially all legislation passed by Congress was subject to the power of judicial review by the courts and ultimately the Supreme Court as the ultimate arbiter of what is constitutional. So in this case, it was that part of the Judiciary Act of 1789, that small part that dealt with the writ of mandamus, that was ruled unconstitutional. But ultimately what the court says that sets up this idea of what is called judicial review is the idea that it is the job of the courts to look at the laws passed by Congress and enacted or implemented by the administrative branch. So the court says it is emphatically the province and duty of the judicial department to say what the law is. This is nowhere in the Constitution, but this is exactly what we have empowered the Supreme Court to do ever since 1803, and according to Marshall, and probably good judgment, we did that before, it's just this is the first time it's written down. So the Supreme Court is not just the last stop, but it is the last, it is the top of the judicial branch of government. And the judicial branch of government is tasked with determining what is and is not a constitutional exercise of the law. So when the court is asked to do that, and you're going to hear about this a lot when Supreme Court decisions come out, there are major methods of constitutional interpretation. So we have judicial review. Judicial review being that the court can look at acts of Congress and invalidate them or uphold them. But how you do that depends on your viewpoint on the law. And so judicial review today looks through a lens of constitutional interpretation. And there are a few major ways that this is done. And I should say that these aren't things that people say, I am this and I am only this. Usually it's just a starting point for someone to observe how law should and should not be made. But textualists are probably the strictest of all interpreters, and they read the text of the Constitution exactly as it is written and do not look beyond the text for answers. This becomes pretty difficult because the Constitution does not speak to certain things that have become commonplace in modern life, like technology, phones, internet, etc., but also because the Constitution is a pretty vague document. So it may be hard to be a strict textualist. Originalists read the text of the Constitution as it was intended at the time it was written. So they first look at the text and then interpret how it was intended to be by the people who wrote it. What did the founders mean when they drafted Article 3? Or what did those who ratified 14th Amendment think it should mean? That's what originalists look at. And then there are people who think that the Constitution is a living document. So these are the living Constitution scholars, for lack of a better term, who believe in interpreting the Constitution in modern-day terms that are relevant to the legal and social issues of the day. And that doesn't necessarily mean rereading the text. You first start with the text as you do with textualists and originalists, but it does mean that you may interpret it differently than the founders would interpret it because circumstances may have changed. So those are three broad things, three broad lenses with which to interpret the Constitution.